Another important landmark judgment delivered by the Supreme Court in the year 1984 relating to right to education, whether it is a part of the fundamental rights and falling under Article 21 which deals with right to life and personal liberty. So, the very important landmark judgment is Mohini Jain vs. State of Karnataka in 1984. The very question that raised it regarding the Karnataka Educational Institution Prohibition of Capitation Fees Act 1984 and the very section, that is section 5 subsection 1, and the very challenge notification by the Karnataka government in the year 1989. So, we would like to discuss their introduction and facts relating to admission into MBBS program and charging capitation fees by the private educational institutions, and the very challenge was made under Article 32 of the Constitution, and whether the private educational institutions are falling under articles, that is Article 12, Part 2 of the Constitution and Article 14, Clause 3 and Article 21 and Article 41.4 of the Directive Principle of State Policy. The issues raised regarding right to education and capitation fees and right to equality and questioning challenge notification issued by the Karnataka government in the year 1989 and the very act charging capitation fees. So, also we will discuss the petitioner's contention and the respondent's argument and rule of law that was established under the Act, then those precedents followed by the apex court while deciding the landmark judgment. The judgment and the very conclusion show the very facts relating to this important landmark judgment, that is the Karnataka Educational Institutions Prohibition of Capitation Fees Act was passed by the Karnataka legislature in 1984 in order to do away with the practice of charging students capitation fees when they apply for admission. The Karnataka legislature released a notification known as the challenge notification on June 5, 1989, in accordance with Section 5, subsection 1 of that Act, to control tuition cost of at private medical schools or institutions. In this notification, tuition cost and other fees were disclosed. The challenge notification stated that students enrolled through government seats would pay Rs 2,000, while Karnataka residents, apart from those with government seat admissions, would pay a maximum annual fee of Rs 25,000. There is a maximum annual fee of Rs 60,000 for students from outside of Karnataka. Ms. Mohini Jain, a Meerut resident from Uttar Pradesh, received an offer by ML to join the MBBS program at Sri Siddharatha Medical College in Agolkot, Tumka, Karnataka, with a session starting in early 1991 requiring a fee of Rs 60,000. However, Ms. Jain further contacted the college authorities stating her inability to pay. She alleged an additional capitation fee of about Rs 4.5 lakh, which the respondents denied. Ms. Jain filed a case under Article 32, Clause 1 of the Indian Constitution, contending that the notification violated articles such as Article 12, Clause 2, Article 14, Clause 3, Article 21 and 41, Clause 4, infringing on the right to education through unjust fees. In brief, the case involved the Karnataka Legislature's Act to stop capitation fees and a subsequent notification regulating tuition in private medical colleges contested by Ms. Mohini Jain due to unjust educational costs. The issues involved in this present judgment, such as does the Indian Constitution provide a right to education, and if it does the practice of capitation fee go against this right? Is the collection of capitation fees for the admission to educational institutions considered unfair and arbitrary, thus violating Article 14, Clause 5 of the Constitution, which ensures equality? Does the challenge notification issued in 1989 by the Karnataka legislature allow private medical colleges to collect capitation fees under the guise of regulating fees as per the Act of 1984? Does the notification go against the Act's provisions which explicitly prohibit educational institutions in Karnataka from charging capitation fees? So the very law established in this case of Mohini Jain vs. State of Karnataka, the rule of law establishes that the right to education is a fundamental right guaranteed by the Indian Constitution. The Supreme Court ruled that this right derived from the fundamental right to life and personal liberty as outlined under Article 21, Clause 6 of the Constitution. It emphasized that the education is a crucial element for achieving social justice and equal opportunity for all individuals. Further, the court stated that education is essential for enabling people to fully participate in society and exercise their fundamental rights. Therefore, the judgment in the Mohini Jain case underscores that the government and private educational institutions must uphold and protect the fundamental right to education. The government is responsible for ensuring that all citizens can access affordable and high quality education, and private educational institutions are prohibited from discriminating against students based on their income or social status. Further, the very arguments by the petitioner charging capitation fees infringe against the fundamental right to education that is protected under Article 21, Clause 7 of the Indian Constitution. A person's whole growth depends on education, which is both a fundamental right and a necessity. Capitation fee policies, which limits access to education based on one's ability to pay, and those in violation of this particular fundamental right. Furthermore, the petitioner claims that the capitation fee regime is unfair and illogical. The amount of capitation fees collected has no logical relationship to how well private colleges educate their students. Therefore, in violation of Article 14, Clause 8 of the Indian Constitution's guarantee of equality, this policy is arbitrary and unjust. Additionally, the petitioner draws attention to the policy's discriminatory aspects, which targets people who are economically disadvantaged, having trouble paying the exorbitant cost. In accordance with Article 14 of the Indian Constitution, discrimination is prohibited. The petitioner further contends that the capitation fee policy is in conflict with the directive principles of state policy included in Article 38, Clause 9 and Article 39, Clause 10 of the Indian Constitution, which place emphasis on the state's obligation to advance individuals' well-being and guarantee equitable access to opportunity. Lastly, the petitioner claims that by treating education as a commodity rather than a public asset, the capitation fee regime is in opposition to public policy. It is against public policy principles for this deviation to occur from the larger public interest, and the arguments raised by the respondents as that too a private medical institution applicants who are accepted by the government seat quota are deemed meritorious, whereas applicants who are accepted under the management quota, which excludes government seat, are not. According to them, the institution has the right to charge non-meritorious students greater tuition fees in order to cover the cost of delivering medical education. They think that this classification is accurate. The Karnataka Private Medical College Association, neither the state of Karnataka nor the federal government provide financial support to private medical colleges in the state. They point out that the cost of an MBBS program in private medical institutes, which lasts 5 years, is approximately 5 lakh per student, because the government quota, which requires students to pay, fills 40% of the available seats only as 2,000 per year. The burden must be borne by the students admitted under the management quota. Therefore, they contend that the tuition fees rate is not expensive and that this structure is not profitable for private medical colleges in Karnataka. Further, they emphasize that neither the Indian Constitution nor any other laws contain any clauses that forbid the collection of capitation fees. So finally, the apex could deliver the judgment that the capitation fees levied by private educational institutions were deemed unlawful, which also upheld the fundamental right to education. The Indian Constitution's Article 21, which protects the right to life and personal liberty and freedom, upholds the right to education as a fundamental right, and that is protected. Further, the apex court found that the capitation fees charged by private educational institutions were a breach of the right to equality as stated in Article 14 of the Indian Constitution. The apex court further observed that these fees were primarily money-making demands made by for-profit educational institutions and had little to do with the caliber of instruction offered by those institutions. The court further observed and made a point of highlighting how these capitation payments led to discrimination against economically underprivileged groups in society who were denied equal educational opportunities due to their inability to pay the high tuition fees. Further, it was observed the government was also ordered by the court to take action to control the capitation fees charged by for-profit educational institutions in order to ensure that capitation fees are not allowed. According to the ruling of the apex court, it is duty of the government to ensure that education remains a right that is open to all people and is not restricted to the wealthy and powerful. So, when the 1989 challenging notification by the Karnataka legislature allowed admission to private medical colleges in Karnataka does not apply to those who were already admitted. The same requirement apply when they continue their studies since he was not admitted based on her qualification and the course had already started. The petitioner was not given any remedy in this landmark judgment, and while delivering the judgment, the appeals court cited several precedents. The legal principles invoked in their judgment regarding the interpretation of Article 21 of the Constitution of India, in particular in the case of Francis Kurali Mullin versus the Administrator Union Territory of Delhi. It was affirmed that Article 21 not only safeguards physical well-being but also encompasses the right to live with human dignity. These include access to basic necessities such as nutrition, clothing, shelter, education, and the freedom to express oneself. Further, the apex court made reference to the president of Bandhu Mukti Morcha versus Union of India, where it was emphasized that the right to live with human dignity, as enshrined under Article 21, draws its essence from the directive principle of state policy, particularly those pertaining to the protection of workers' children, health, and human working conditions. It was established that these minimum requirements are essential for individuals to lead a life with dignity, and no government, whether central or state, has the authority to deprive people of these fundamental essentials. Accordingly, the apex court highlighted the evolving interpretation of Article 14, emphasizing that equality under the law is fundamentally opposed to arbitrariness, and this principle was derived from another important leading case such as Maneka Gandhi versus Union of India, as it was decided in the year 1978. So, prior to Mohini Jain vs. State of Karnataka, which was decided in the year 1992, there existed a lack of consensus regarding whether the right to education was indeed a fundamental right guaranteed by the Indian Constitution. Different courts had held different views on this matter, with some recognizing it as a fundamental rights and other not recognizing right to education as a fundamental right. Furthermore, there was no legislation in place that explicitly prohibited private educational institutions from imposing capitation fees. Consequently, many such institutions were imposing exceedingly high capitation fees, rendering education financially inaccessible for economically disadvantaged individuals. The Mohini Jain judgment brought about a significant transformation in this landscape. The Supreme Court, through this landmark judgment, equivocally established that the right to education is indeed a fundamental right enshrined within the Indian Constitution. Furthermore, the apex court ruled that the practice of private educational institutions charging capitation fees was in violation of the right to education. This pivotal judgment was having far-reaching consequences within the Indian education sector. It has democratized education access, particularly for those with limited financial means, and played a role in curbing the imposition of capitation fees by private educational institutions. Importantly, the principles outlined in this judgment continue to be binding on all Indian courts. Nevertheless, challenges persist in fully implementing the judgment. Some private educational institutions have found ways to change similar fees under different names, and there remains a shortage of educational institutions in the country, hindering widespread access to education. Despite all these hurdles, the Mohini Jain judgment stands as a watershed moment in the Indian education landscape, solidifying the fundamental right to education and making it more attainable for marginalized communities.